Hello, this is Dave Drabkin, and I'll be joined by Chris Yukins. We're from the AIRC at the Stevens Institute of Technology, and today we're going to share with you reports that we were directed to um, create for Congress about two aspects of government procurement at the federal level in the United States. Before we go too far along in the process, I hope that all of you in the audience are aware that in the United States, there's a big distinction between what's done at the federal level for procurement and what's done at state and local levels. And of course, the commercial sector is completely separate.
So what I'd like to do a little bit, just give a little bit of give a little bit of my background, then Dave will give a little bit of his. I'm Chris Yukins. I'm a professor at George Washington University Law School in the Government Procurement Law program. I've been a professor since 2002, and I regularly join this conference in Stockholm. We apologize that we can't be there in person this year. I'm recovering from COVID. So Professor Sundstrand very kindly allowed us to present by video. We really enjoy our time in Stockholm, and Dave and I really wish we could be there in person. I work with Dave on this project for the AIRC, the Acquisition Innovation Research Center, as part of my professorial duties. And it was an effort to try to address some of the emerging policy issues regarding both bid protests or bid challenges, as they're referred to in Europe, and debarment or exclusion in the U.S. system. Dave, do you want to just chat a little bit about your background?
Sure. I am not a professor and I'm not an academic. Most of my time in government contracts has been done at the performance level. I served as a legal advisor in the United States Army to contracting activities in the Defense Logistics Agency and the Defense Contract Management Agency. I served at the OSD, the Office of the Secretary of Defense level, as a policy person. I went to the General Services Administration, where I served as the senior procurement executive for 10 years. I got to spend a little time on the Hill writing legislation, which, by the way, got passed. And then I went into industry and worked with Northrop Grumman for 7 years as their director for contracts at the corporate office. Chris and I have been working together since, I think, the 2000, when I showed up in a class he was teaching, trying to earn my LLM. And I am ashamed to say that I still owe Chris my thesis, for which he reminds me regularly.
David and I teach the procurement reform class informally. He's been very kindly joined me now for 2 decades. So the first class I was teaching as a professor, the first class I walked in, and there was Dave Drabkin sitting in. And Dave at that point was one of the top 3 people in procurement in the federal government. So you can imagine my terror as a young professor having to teach Dave. The joke is I was suddenly asked to teach the Bible to God. So it was quite an experience. And Dave very kindly supported me through that first year. And he's really done a wonderful job in our class, because as we talk about procurement reform in the United States, David's been personally involved in a lot of it, and he can share very important insights with our students. So thank you very much, Dave.
No, it was my pleasure. We actually are going to talk about 2 studies we were chartered to do. First, we were chartered to go and look at what you refer to in Europe as bid challenges in the United States at the federal level. Anyway, we refer to it as protests. There is no movement currently to change the language at the federal level to be more closer to what you refer to it in Europe, and by the way, probably the rest of the world as well. About midway through the first 3 months of our study, all of a sudden an issue arose in Congress about debarment of labor law violators. There were significant members in both the House and the Senate who were concerned that the federal government, when awarding contracts, was not looking at a company's experience for labor law violations, and they wanted to look at possibly creating a statutory requirement to debar contractors who were frequent and substantial violators of labor law. And so they asked us if we would put a short hold on our bid protest study and crank up a quick study on labor law violations and debarment. Chris and I were able to do that, and from their perspective, it was really good news because we thought we could do it with the money they already gave us.
The bid challenges study that we did fell after, and I'll be discussing this in more detail, a study that I did for a separate body, the Administrative Conference of the United States in 2019. That report was specifically on agency level bid protests. So some of that work carried over into what we were doing here in this Defense Department related study. The debarment study was, as Dave suggests, it was kind of interesting. It was sort of an afterthought, but it turned out to be a very important part of the policy discussion on Capitol Hill in terms of whether or not labor violations would be an automatic ground for exclusion of contractors.
Yeah, okay. So the background for the AIRC. One of the things I did in my past was I chaired the Section 809 panel, which was a congressionally directed study at acquisition in the Department of Defense. Our report was completed and submitted to Congress in January of 2019. And as part of that report, the Section 809 panel recommended the creation of a body within DoD that would, on a continual basis, look at issues associated with acquisition reform, as opposed to doing periodic major studies on acquisition reform. The substance of that recommendation was not adopted, but subsequently Congress directed the creation of a center in a university or universities that would support the Department of Defense and do research on government acquisition issues, more focused initially on engineering issues, but has been broadened to cover the whole gamut of acquisition reform. So the AIRC was formed. It now sits at the Stevens Institute of Technology in New Jersey. And it has put together a consortium of universities across the country, including a focus on historically Black colleges and universities. And work is sent to them with money from DoD to do studies. And so this assignment was sent to them. They reached out to Chris, and Chris asked me to join, and we put together this team. As you can see, it was me, Chris, and then we had several law students who joined and supported us in various research functions.
The researchers were interesting. I just want to highlight a couple of them. Besides, all of them were excellent. Just but a couple want to highlight a couple of them for the work that they've done outside. Will Dawson, who joined us, did independently a study that was published in the Public Contract Law Journal, a statistical study of government accountability bid challenge decisions. So the decisions that are published by the Government Accountability Office, the bid challenge decisions, there are about 1,200 or so published every year. Those decisions have a consistent format, and he exploited that consistent format to find data patterns. So, to identify, for example, common issues that are presented. Will was actually even able to calculate the win-loss record for individual attorneys in the bar. So it was really an extraordinary study that he did. And these studies were published, some in the Public Contract Law Journal and some fed into the study that we were doing. But he's an extraordinary example of a young researcher being able to use data to gain some really interesting insights on what's happening in the procurement system.
Yeah, and that does bring up, you can keep going to the next slide. It does bring up something that I don't know how you look at it in Europe. I'm sure Chris will tell me in just a second. But here in the United States, people talk about winning or losing a bid protest. I'll share with you a short anecdote. My son is also a procurement lawyer for a private company where he's also the vice president and general counsel. He called me one day, not long after having gotten that job, and said, "Hey, Dad, I won my procurement protest." I said, "That's really great, son. Call me back when you get the contract." Because in the United States, at least, when we talk about winning a bid protest, it does not follow that the contract that's the subject of the protest was won and awarded to the protester. In many cases, it means that the process was stopped and then restarted, and no one is really keeping track of the numbers of the companies who, after filing a protest, actually received the contract that they protested. And that's an important concept to keep in the back of your mind. And it's one that when I was in government, I regularly challenged the GAO when they came out with these statistics talking about their success rates, because they counted success rates as the agency withdrew the contract, or the agency recompeted the contract, or the agency reconsidered the award decision, not that the contractor actually got it. And in the United States as well, and I'm sure it is true there in Europe, for a small business, this is a real issue because they spend time and money, possibly they're afraid that they might upset their potential client by filing a protest, and then they don't get it. It seems in many cases to them as though it's not a very rewarding effort.
Just a couple data points on Dave's observation. This is the study that we're about to talk about is one in a long series of studies. There was an earlier study done by the Rand Corporation, which dates back to the 1960s. The Rand Corporation is a very important research and development tool for the Air Force and for other parts of the Defense Department. The Rand Corporation did a study on bid protests in the Defense Department and found that really only a very small percentage of procurements, about 0.3% of procurements, are actually protested. Rand did not make an attempt to assess what the question that Dave raised, which is, if you bring a bid challenge, what are the chances that you'll actually ultimately win the contract? A colleague who previously taught with us at George Washington, Dan Gordon, did try to do that analysis using slices of data on particular bid protests from GAO. He'd worked at GAO, so he had good and trusted access to data from GAO, and he found that if you looked at contractors who brought bid challenges, the ones who won the bid challenge and then ultimately won the contract was very, very, very tiny percentage. And when he published that, it caused a lot of consternation in the procurement community, especially among the lawyers, because in essence, he was arguing that there was no point to bringing a bid challenge. But then subsequent to that, he did a follow-on study, not looking just at the win rates for the protesters, but looking at the win rates for the protesters, including those protesters that received corrective action from the agencies. And in those cases, the win rates, the success rates were much higher. What his two studies put together mean, in essence, is if a contractor brings, a vendor, a bidder brings a bid challenge, the chances of ultimately winning the competition, the recompetition, are relatively low unless the agency is willing to take corrective action early on. And that the willingness of the agencies to take corrective action really varies. It turns on the individual agencies, but it's an important part of understanding the American bid challenge system, that corrective action taken early on by the agencies is an important part of the process.
Okay, so what were we actually asked to do? In the United States, our acquisition statutory guidance from Congress normally comes through the National Defense Authorization Act, which has been since 1953 or 4, has been passed every year without fail. Some years in the last 2 decades, it's been a little late. It's supposed to be passed and enacted by the 1st of October. And you will see that I think only once in the last 20 years, when they named the act in honor of Senator McCain, did it actually make it in time. And in truth, I think it made it in time because they wanted him to see it before he died. He did die shortly thereafter. So anyway, the National Defense Authorization Act is where acquisition and contracting guidance comes from. Typically, that appears in what's called Title 8 of the NDAA, and it is also, even though it's for the Department of Defense, if there's any critical changes to the overall system for the whole government, they also appear here in Title 8. There have been only now in the last 20, 30 years, there's only been 3 standalone acquisition bills. One was called the Federal Procurement FASA, the Federal Acquisition Streamlining Act of 1994. There was the Services Acquisition Reform Act in 2004. And then just recently, there was one on organizational conflicts of interest. So in the FY21, the fiscal year 21 NDAA, the fiscal year being over, beginning on the 1st of October and ending on the 30th of September, in 21, there were 4 points which DOD was told to look at. First, the rates at which protesters are awarded the contract that was a subject of bid protest. We've already talked a little bit about that. Second, the time it takes to implement corrective actions after a decision. Third, the analysis of the time spent in each phase of the process in dealing with protests. Then fourth, and the analysis of the number and disposition of protests filed within DOD. Congress couldn't wait for us to finish the study. And so in the FY22 NDAA, they added some additional guidance. They wanted to know the benefits of what's called an agency level bid protest, where the protester goes to the agency that awarded the contract, typically in the U.S. system to the contracting officer, him or herself, and files a protest. Second, to study or evaluate the following for agency level bid protests, and that is, you can see them here, I won't read them to you. And then review existing law, the federal acquisition regulations and policy, and solicit input from across DOD and its stakeholders, which this 4th bullet added a time element to the work we had to do.
So our basic research questions have been framed by Congress, and we were trying to apply a different normative structure, a different hypothetical to these research questions, and really taking a big picture approach, partly based on the experience and the findings of the Section 809 panel, which was a blue ribbon reform panel that they referred to. He was the chair of the Section 809 panel. And when you hear us refer to sections, they're almost always sections in an earlier version of the National Defense Authorization Act. That was true of the Section 809 panel. Section 809 is what launched this blue ribbon panel that Dave led. And so the question we really wanted to apply, this conceptual structure we wanted to apply to bid challenges, which really is applicable to bid challenges anywhere around the world, is do bid challenges serve two roles? In Europe, if you look in the European Union and the Remedies Directive and the general approach to remedies, certainly under the Remedies Directive, is that remedies are intended to address issues of competition, to assure that there is fair competition, ensure bidders who feel like they've lost due to a misapplication of the rules, give them an opportunity to bring a bid challenge. The Remedies Directive and bid remedies, normally when we talk about them, they're about ensuring fair competition. We think, based in part on the work that David done on the Section 809 panel, and really a broader approach in the U.S. procurement community, that there's a second role for bid challenges to play. That bid challenges can actually be a management tool. They can be a red flag system. We have whistleblowers who are bid challenges. There are vendors who are willing to bring bid challenges, and those vendors highlight for the managers of the procurement system where failures have occurred. They're essentially a red flag system for the procurement process. And so that second management tool, that second aspect of bid challenges, is something that we wanted to focus on in this report.
Yeah, we spoke to all of the senior managers within the Department of Defense for the Section 809 study about this issue. And surprisingly, all of them were in favor of keeping the bid protest process precisely because they thought it could be used to give them an understanding of where they had problems in the process and could pay attention.
The bid challenge process is been ingrained in the U.S. system, certainly back to at the Government Accountability Office, certainly back to the 1920s. It's also something that the United States is committed to under various international trade agreements, and importantly, the United States and most nations around the world have committed to bid challenges, to having bid challenge systems under Article 9 of the UN Convention Against Corruption. So just want to talk for just a second, Dave touched on this before, but just explain where agency level bid protests fit in this overall structure of bid challenges in the United States. And this is a three-part structure we see across Europe, we see around the world. For instance, the UN model procurement law, the UNCITRAL model law talks about this three institution approach, where the first pathway for possible bid challenges is through the agency itself. I'm sure this dates back to ancient times. I'm sure that Roman contracting officials would have heard complaints from bidders. That's essentially an agency level bid protest. So that's one pathway. A second pathway is an independent agency, such as the Government Accountability Office. And the Government Accountability Office in our system in the United States has a very highly structured bid challenge mechanism. And relatively few vendors will go to the agencies, even though it's a rapid and relatively cheap strategy. The vendors don't want to go to the agencies because they're in essence asking the agencies to rule against themselves. And most agencies, the vendors feel like they can't trust the agencies to rule against themselves. So they'll go to GAO. They'll use this independent agency forum, and GAO, as I said, has well over 1,000 cases every year. Compared to the Court of Federal Claims, the Court of Federal Claims only has about 1/10 as many cases, because the Court of Federal Claims is a much more laborious process, and it can take much longer. And the cost, unlike GAO, where the vendors can predict with some certainty as to what their costs will be in bringing a bid challenge, at the Court of Federal Claims, it's much less certain. So vendors tend to steer away from the Court of Federal Claims. It is possible, though, for a vendor to bring a protest that spans across all three, to bring one of the agency first, then go to GAO, and then go to the Court of Federal Claims. And then, of course, after the Court of Federal Claims, an appeal can be brought to the Federal Circuit and then ultimately to the Supreme Court, if appropriately. if appropriate. So as I said before, I worked on an earlier report for the Administrative Conference of the United States on agency level bid protests. And that report was launched in 2019. The draft report was published in 2020, and then it was ultimately adopted by the Administrative Conference. The Administrative Conference of the United States is an agency within the U.S. government that provides very, very high level administrative law recommendations to the other executive agencies. And this was the Administrative Conference of the United States, for various reasons, hadn't really dealt with public procurement, with federal procurement since the 1990s. This report was an important effort on the part of AICUS, the Administrative Conference, to step back into the public procurement world. And the draft report that I prepared was subject to extremely thorough review by very high-level administrative lawyers and professors from around the country, and it's an excellent example of work that could be done at a very high level in administrative law, bringing those lessons from administrative law into the procurement sphere. And then the AICUS report in turn was used as a foundation stone for the AIRC, the Acquisition Innovation Research Center report that we're talking about today. So the recommendations that we came out with for agency level bid protests really are, the recommendations are as important for your purposes as Europeans. The recommendations are important to understand weaknesses in our agency level bid protest system. So one is that we recommended that these recommendations were then carried into the report that Dave and I worked on as well, that there be an effort to formalize the role of an agency protest official. The agency level bid protest, as I say, probably existed all the way back, in ancient times, but they had been formalized in the U.S. system after World War II. And then in 1994, President Clinton, as part of a broader effort to reform the government and really to reform federal procurement as part of that, President Clinton issued an executive order calling for the formalization of agency level bid protests, and individual agencies had developed different processes to make agency level bid protests work better. And all we were doing was drawing on best practices across the government. And one of them is an agency protest official. Those agencies that have agency protest officials who can oversee the agency level bid protest process, they bring a formality, they bring a structure, they bring sometimes transparency. They certainly bring oversight to the agency level bid protest process in the individual agencies. So that's one of the recommendations that we made. The other is that the second recommendation we made is confirming that agencies have broad authority to hear agency level bid protests. This seems like a silly recommendation. Why would we have to bother to tell agencies that they have authority to review their own actions? The answer is that there is an important area of development in U.S. federal procurement called other transactions. And Congress has lent the Defense Department and other agencies authority to enter into transactions that are outside the federal acquisition regulation, really what we refer to sometimes as the Wild West. There's been tremendous controversy about whether or not those actions that are outside the other transactions, which are primarily in the area of research and development, but also can carry into production contracts, whether or not those actions should be subject to scrutiny through the bid challenge system at GAO and at the Government Accountability Office and the Court of Federal Claims. So the suggestion here is that really as an additional layer of accountability of oversight for these types of other transactions, which is what they're called, that there be agency level bid protests available as well. The third is that the standard for standing be flexibly bound to that of the Government Accountability Office and the courts. This normally standing in the United States, in order to have standing for a bid challenge, the vendor has to show that it was next in line for award and was injured by the agency's mistake. And that's a relatively stringent standing standard compared to other countries. A student of ours named Ian Hargreaves did a study of 99 jurisdictions, including under the Remedies Directive in the European Union. That was published in the Public Contract Law Journal. He showed that standing rules are really all over the place. And in some countries, for example, unions have standing. In some states in the United States, taxpayers have standings to bring bid challenge. Taxpayers who've never bid at all can bring a bid challenge. So the question of standing can get very elastic depending on whom you want to allow to be a whistleblower. The idea here is that agency level bid protests would stay within the tradition of the Court of Federal Claims and the GAO, saying next in line bidders would have that standing. That the decision-making process was the fourth recommendation, should be clarified for agency level bid protests. There is a very highly formalized administrative process for contract claims. After award, the actual contract administration disputes, there's a very highly formalized process for contracting officers to hear those claims and in essence to act as judges, act as the first layer of administrative judges in resolving these post-award contract claims and arising from contract administration. Well, ironically, right next to that process in the Federal Acquisition Regulation is agency level bid protest, but there is really no highly structured process for agency level bid protest. And the decision-making process, we argued, should be more carefully formalized, again, drawing on best practices from various agencies across the government. The record should be specified. The record needs to be very, very clear for the protester in order for the protester to feel like it's a valid process. What's the sixth is, and related recommendations to maximize the record share with agency level bid protest. Some agencies don't, and when there's an agency level bid protest, they don't give the protester any information. That approach is increasingly difficult in the US system as we move towards open data. The United States has open data laws that are beginning to change the structure and the approach to procurement data. And it's very possible in the next few years, next decades, that everyone will have access to much more data inside the federal government. And as a result of that, the approach that's taken historically to agency level bid protests, where presumptively none of the administrative record is given to the agency protester, the protester has to kind of guess at what went wrong in the process, that would change. There should be a rationalized stay of performance in the event of an agency level bid protest so that the procurement is stopped. That stay, which is the standstill you see under the European Remedies Directive, that stay isn't in place for every single procurement. It's not like the example we see under the Remedies Directive in the European Union. Instead, only those procurements that are challenged are actually stayed. It's not an automatic thing across the board. And our recommendation was that stay needed to be normalized because a protester needs to feel that it has a reasonable opportunity of ultimately winning the award, because that's the only incentive in the US system for that's the only incentive for being a whistleblower. If we take that away, if it's impossible to ultimately win the contract, then the challenge will have no incentive to bring a challenge. And the last is that data should be published on agency level bid protests. Part of our study was to look at the Defense Department data. We found that really the Defense Department data was very fragmentary. And so it's very difficult to discern patterns, even in the protests themselves, and certainly very difficult to discern any patterns in the types of issues that were being raised.
Okay, let's go to the next slide. So let's talk about the debarment study that we did. There was pending legislation that would have required the debarment of vendors who violate certain labor laws, not all of them. They were particularly upset about a couple in particular. But in the United States, like in Europe, we have a whole slew of labor laws in terms of how we operate businesses in the marketplace. And so they asked us to look at whether it made sense if a contractor was found to have been an egregious violator and a frequent violator of labor laws, to have that result in what we call here a statutory debarment. In other words, the statute directs, without any discretion, that if you are found to have satisfied those conditions, that you will then be debarred. And although I guess I assumed and I didn't explain it in the opening, debarment in the United States means you cannot receive a new contract. You also now cannot get an extension on an existing contract, and it can be used as a reason for not for exercising an option on an existing contract. So it's a pretty heavy tool to wind up with a debarment. And in our system, the Department of Labor has its own authority to debar contractors, regardless of whether they actually buy from those contractors or not. But in the Department of Defense, for whom this study was requested, we needed to look at also how debarment officials in the Department of Defense treat labor law violations. It's also important to know that we don't have lots of debarment officials in the federal government. Most agencies have only one, usually at the headquarters of the agency. In the Department of Defense, there's probably, I think I counted 12, but that number changes as agency organizational structures change.
Just to mention, Dave touched on it very lightly during our introduction. Dave actually served as a debarment official when he was at the General Services Administration. So he has firsthand experience on how this debarment system works.
And I had a couple of doozy debarments to deal with that made the news, and my decision didn't make anybody happy. Although Arthur Andersen, a large accounting firm in the United States, was put out of business by my decision to debar them.
Related, that case involved Enron, which is an energy trading company in Houston. Arthur Andersen was the accounting firm caught in that same scandal. The Enron had political ties to the Bush White House, and so the question that Dave was presented with as a debarment system, as a debarment official, was whether or not a contractor should be suspended based upon a general bad acts that were occurring with Enron outside the procurement sphere. And it was all colored by this overarching issue of the fact that Enron had political ties, located in Houston, had political ties to the Bush political base. So it was a very complicated situation that Dave found himself.
Yeah. Well, we made new law. We found that a company's bad acts would not be limited to just what was associated with a particular government contract. We determined that if a company was a general bad actor, we didn't want to do business with them in terms of protecting the government going forward. And besides, I was a civil servant. They couldn't fire me.
I vigorously disagreed with Dave at the time. I thought at that point that debarments should only be based on bad acts that are going on inside the procurement system. But as the debarment process, this is in the early 2000s, as debarment has evolved, as exclusion has evolved both in the United States and really internationally, and evolved very rapidly, we've seen that I was wrong and Dave was right, that more and more public entities will look to activities going on outside the procurement system as they're assessing suppliers for potential exclusion or debarment. That's certainly true under Article 57 of the EU Procurement Directive. The Article 57 looks to, for exclusion purposes, looks to acts that are occurring outside the procurement system.
And we're going to cut that clip out of this presentation because I want to replay that where Chris is saying I was wrong and Dave was right. Thank you.
It's all going on YouTube, Dave.
There you go.
So just to give a quick summary of where things stand in terms of the exclusion world, because it's important to understand where we're going in our study. The norm that we deal with in the United States is here in the middle. Normally when people talk about debarment in the procurement world, we're talking about discretionary debarment. This is under subpart 9.4 of the Federal Acquisition Regulation, and the suspension of the debarment official has broad discretion to exclude businesses It's really a business decision. Exclude businesses that pose risk to the government. The focus is technically on performance risk, but there are very, very heavy components. As Dave will explain, that normally the debarments you see aren't performance-based, but rather based, for example, on a criminal conviction, which raises reputational issues for the United States. It is a supply chain risk, but a supply chain risk assessment, and it is not a mandatory process. We're going to be talking, what Dave was alluding to before was a mandatory debarment process for certain types of statutory violations. And that was the core of our study. But you can't really understand the mandatory debarments unless you understand the discretionary debarment that is the heart of at the heart of the U.S. procurement system. Now, that is the discretionary debarment by a debarring official is really a souped up or amplified version of the exclusion decision being made by and it's called non-responsibility or non-qualification being made by contracting officers in individual procurements. And that's what you see under Article 57 of the EU directives, that type of procurement by procurement exclusion that's on the left-hand side here in the green box. That's done by contracting officials. And if you looked at the standards for debarment under FAR subpart 9.1, excuse me, 9.4, the standards for debarment under 9.4 actually track relatively closely with the standards for non-qualification under 9.1. It's best to think of the contracting officer working on an individual procurement and the suspending and debarring official working at a much higher level, really in effect on a government-wide basis assessing risk. The mandatory debarments over here on the right-hand side, these statutory debarments are called for by certain statutes such as the Clean Air Act and the Clean Water Act for violations. And we're going to be talking about those in more detail. And those run alongside the discretionary debarments. Most contractors and most folks in the procurement community are focused on the discretionary debarments, but these types of statutory or pseudo-mandatory debarments on the right-hand side are really the focus of the report, because as Dave explained, our report was triggered by an effort by members of Congress to make violations of certain labor statutes a mandatory basis for debarment.
It's important to keep in mind as you look at this chart, on the left under non-responsibility termination, that's a picture in time. The time is when the contracting officer has completed all of the various contracting activities and is about to award the contract. That's the point in time that the contracting officer has to determine whether or not the contractor is responsible. That determination is made upon information that's available to him or her at that moment. The contractor doesn't get an opportunity to respond or plead its case. That's the contracting officer's decision. If the contractor disagrees, it's a basis for a protest. Whereas in the middle and on the right, there's a much more formalized process, which includes notice, an opportunity to be heard, and judicial review of those decisions.
So Congress asked for when we say Congress, one of the nuances here is that the staff person who's taking the lead on this was in the Armed Services Committees was actually a former colleague of ours, and we talked with her. She, of course, was not the explicit author of the direction from Congress, but she was an important part of shaping where these directions from Congress were coming from. And what she wanted was an assessment of adjudicative debarments. If you look at the federal system, the U.S. federal system, the debarment process is relatively informal. If you look a few hundred meters away, when Dave was working at the General Services Administration, just a few hundred meters away at the World Bank, they have their own sanction system and their own debarment system. And the World Bank sanction system, debarment system, is much more tightly defined. It's much more of an adjudicative process as opposed to a relatively discretionary administrative process. So the World Bank has considered going the same way as the Americans have, having this more informal, really risk-based process. But if the World Bank did that, if they didn't have a tight set of rules and a tight set of procedures, there's concern that they would lose the legitimacy with the borrower countries and with other stakeholders. So they have a very tightly adjudicative process. In our report, we recommended that the United States not change direction, the United States not deviate from its relatively loose and informal debarment process. And this is really a question for European nations too, as member states implement Article 57 and as potentially Article 57 would be revised in the next version of the European Procurement Directive. Should there be a more tightly structured process, or is the American approach, which is a more informal and risk-based approach, is that the right way to approach discretionary exclusions, discretionary debarments?
I think the second bullet on that last chart is worthy of accentuation. In the United States, debarment is not a punishment. It can't be used by the courts, for example. They can't debar a contractor. Only the government contracting agency can. It is a means to protect the government from doing business with a dishonest or not responsible contractor. And that even though that's been our practice since the beginning of the use of debarment in the United States, it's something that is hard to explain to the legislators, for example, who want you to use debarment as a punishment for bad actors. And that was part of what led to this call for our study.
On Dave's point, was we want to try to explain this to you as a European audience. We really aren't introducing you to or bring you into our system of laws and asking you to embrace it. What we're trying to explain is that the discretionary debarment system that we have in the United States and the federal government, that discretionary system is something that's very close to a supply chain risk analysis in the private sector. A private sector customer will assess vendors for risk. And that's exactly what the federal government is doing. There are different types of risks that the federal government is looking at. The federal government, for example, is more concerned with reputational risk than a private vendor might be, but it is a risk analysis in both the public sector and the private sector. And as Dave and I believe, is at the end of the day, that's the strongest argument for the US system. It allows the government to do a risk assessment.
Yeah, my objective when I wore my hat as a debarment official wasn't to throw somebody out of the process, but it was to make somebody responsible. I had tools I could use to oversee their rehabilitation, because I want more companies doing business with the government, not fewer. So I don't want to throw them out of the process unless they are completely, they can't be fixed. They can't be trusted. By the way, in some of the arrangements that debarment officials in the United States use, I literally have more authority than any agent, any law enforcement agency, any oversight agency to go into a company unannounced, romp through their books, look at how they're performing their actual work, than I would have had it been a judicial decision. So it's a great tool to help bring a company back into compliance and good corporate citizenship.
The remedial measures that Dave is talking about are corporate compliance measures that have really been built up in the US system since the 1960s. And they are the same type of compliance measures that you see in the European directive. Article 57, paragraph 6 talks about self-cleaning measures, or in German, the Selbstreinigung measures that a contractor can take to try and remedy the wrongs that it's done and remedy the internal failures. Those are exactly the types of remedial measures that Dave was looking for as a debarring official when he was assessing whether or not to exclude a contractor for a term of years, or debar a contractor.
Well, we completed our report. We did it on time and we submitted it on time. And I understand that our debarment report is now available online at the AIRC site. So please, if you have a moment, take a look. It'll provide you with a history to give you a little better idea of how we got to where we are, and then it'll talk about the various specific issues and questions we answered. So, possible approaches to labor law violations. First, let me start that I began with a prejudice. My entire time, 30 years in the government, I believe fully that the Labor Department ought to be the responsible agency for dealing with debarments involving labor laws. They have the expertise, they have the staff, and they have the authority. But Congress wanted a broader approach to possible ways to deal with labor law violations, in part because the Department of Labor already has been tasked with doing that under 2 other statutes. And as you'll see in our report, they're not very big about debarring people, even when they find that they've violated the law themselves. So then we looked at the contracting agencies' discretionary debarments, things that go to the SDOs, the suspension debarment officials in the various agencies in DoD, and looked at there, and there we saw that there are issues. Clearly, those folks are better trained, better staffed, better supported, but again, they're not labor law experts. They don't understand necessarily the nuances of a particular violation. The contracting officer's responsibility determinations, as I explained before, which is a picture in time. The contracting officers don't know much about any of these labor laws. They have to deal with hosts of issues, and it's not practical, and it's not to try to train them up. And it's also not practical to provide them with that kind of support. We have 2,500 federal government contracting offices scattered throughout the world. We can't provide them with that level of expertise, practically speaking. And then we came up with, as we were looking through this, as a possible fourth alternative. In our system, contractors have to submit certain certifications and representations about a whole host of various issues. And so we thought, who better to know whether they had been found finally in violation of a labor law than the contractor, and require them to add that to their certifications and representations so that a contracting officer would be able to see whether we got somebody who's had 15 of these things in the last 12 months or somebody who's had one problem over the last 15 years.
So this is the area, the question of labor law violations is very complex because the Department of Labor will apply to American companies, the contractor community included, many different types of labor laws. The Fair Labor Standards Act, some of them are specifically directed to government contractors. So for example, the Service Contract Act requires service contractors to apply prevailing wages in their service contracts. The Davis-Bacon Act takes the same approach to construction contracts. So there are government contracting specific labor laws, and then there are other labor laws as well that apply generally across the economy, like the Fair Labor Standards Act. What we found during the study was that the Labor Department, when it is addressing contractors or vendors in general, companies in general, that have violated labor laws that should otherwise be, that might otherwise be mandatorily debarred, the Labor Department will sometimes allow those vendors to come back in. Will say that they are not debarred because the vendors, the companies, have taken certain remedial measures. So, and the Labor Department's first goal oftentimes in negotiating those remedial measures is to ensure that the workers who have been injured are in fact compensated by the companies. So It is a subset of the type of remedial measures that you actually see under Article 57, paragraph 6 of the directives, that before contractors are allowed to get back into the European procurement system under Article 57, they have to give victim compensation. Same is true under this Department of Labor system, that the Department of Labor creates a flexibility. What seems like a mandatory department system really isn't, because the Department of Labor will allow these companies to continue to perform if appropriate remedial measures are taken.
And so we've talked about it briefly, I talked about it briefly, but here, take away from this just the fact that someone gets proposed for debarment does not mean they should be debarred. Remember, debarment in our system is not punishment. It is a means to make sure that a contractor comes into compliance and performs in a compliant manner under our contract. In the discretionary debarment for labor law violations, we made these three findings. I won't read them to you. You can read them to yourself. But here's the bottom line. We think that it ought to be used sparingly. We talked about contracting agencies themselves not having the expertise in labor laws sufficient to actually run a in-depth program. And we thought that the Labor Department should reserves its use of discretionary debarments itself to address labor law violations for instances in which there is an associated criminal indictment. In other words, statutory debarments aren't going to get people in Congress what they want, which is the government not doing business with a bad actor.
From a European perspective, from an outsider's perspective, some of the lessons here are that an agency that is tasked with exclusion that is not the procuring agency, in this case, the Department of Labor, an agency that is tasked with exclusion, a third-party agency, so to speak, it has conflicts of interest. The conflict of interest of the Department of Labor is, first, that they care first about making sure that the workers are compensated, and they're letting the contractors back into the system if that's met. And they're not making a procurement risk assessment. They're really making an assessment as to whether or not the workers, the victims, have been addressed appropriately. The second is that the reason that the Department of Labor is in fact barring those few contractors that have criminal convictions is the Department of Labor wants to save time in the debarment process. The debarment process has due process constraints, and so it can absorb a great deal of manpower to actually go through a debarment. In the case of a criminal conviction, many of those due process concerns evaporate because there's already been a criminal conviction. There's no need to afford more due process. So the agency has a conflict of interest in favoring the pathway, not based on, it'll take the pathway, not necessarily based on procurement risk, which is the normal crux of a debarment system, but instead, this third-party agency, Department of Labor, is making decisions based on transaction costs, which is perfectly natural for the agency, but it's something to think about because this has been a recurring point of debate as debarments and exclusions evolve in Europe. Should that debarment or that exclusion function be put into a third-party agency, into an outside agency? And I think the U.S. experience here is that that creates its own issues. So just statistically, to give you an idea, we don't want to dwell too long on the statistics here, but we just want to say that there are literally hundreds of Service Contract Act, for example, violations every year. And the Service Contract Act is a statute that covers government procurement. This is not something happening outside the procurement realm. This is a violation of law inside the procurement realm by definition, because the Service Contract Act regulates federal procurement. Even though you have these many violations, hundreds of violations, you actually have relatively few debarments. You see here in the order of 7 or 8 a year, a tiny number of actual statutory debarments, even though on its face, the the Service Contract Act calls for mandatory debarment. So a lesson here for outsiders, for Europeans, is even though the statute might call for a mandatory debarment for a statutory violation, in fact, the implementing agency, the Department of Labor here, may never actually do that. They may find back doors in order to allow the vendor to continue to participate in public procurement for the reasons, the conflict of interest I talked about before.
Even though, keep in mind that it's their statute, and it's their regulations, it's their investigations that uncover all these violations, they still, I mean, look at the numbers. It's almost obscene. It's so few.
The Department of Labor statistics on Service Contract Act violations and all the labor law violations we're talking about are available on the Department of Labor website in the Wage and Hour Division website. So all this data is available publicly. It's available, you can download it into a spreadsheet, for example, and depending on what format you want to download. All the data on the violations is available, but making sense of it and understanding how little actually is happening in terms of how few contractors are actually being debarred, even in the case of a mandatory statutory debarment. That's something that our study was really needed for. So just want to give you an idea. The other concern we had going into this was, okay, if we do make debarment mandatory, if every single violator is let's say the Fair Labor Standards Act, which was the statute that was on the table as we undertook our study. If we make every single violation a potential source of a mandatory debarment, what will happen to the supplier base? Because at the end of the day, that's the core concern for the procurement community. What impact will this have on, for example, the Defense Department supplier base, which the Defense Department spends enormous resources reinforcing the defense industrial base. It's considered an integral part of the national security of the United States to have a strong defense industrial base. So what would happen if we just started applying mandatory debarment to those that engage, for example, in Fair Labor Standards Act? And you begin to see in the right-hand side, this is some of the study that the data study was done for our report. You begin to see that a really significant percentage of Defense Department contractors have reported Fair Labor Standards Act violations.
Yeah, and that's really important to keep in mind, because again, keep in mind that in the United States, debarment and suspension is a method for increasing and improving the responsibility of contractors, not punishing them. And we can't have a large segment, particularly of our top 10 DoD contractors, to be debarred and not be able to service us. Here's a non-labor act anecdote to share with you. In early 1990, I was at the Defense Logistics Agency in the Office of General Counsel, and our debarment official on a Friday afternoon decided to debar GE engines. Now, that may not seem like a big deal to those of you who don't understand what that means to the armed forces, but that meant that on Saturday, after the debarment was issued, they had to ground the entire fleet of naval aviation, the entire fleet across the globe. And that's a consequence that we can't live with. And so when we look at how we deal with these issues, we need to look at the purpose of debarment and suspension, which is to improve and increase the number of responsible contractors, not use it as punishment.
That has a practical impact practical meaning for Europe as you consider evolving debarment systems under the European directives, and the recitals to the European directive allow the member states to do that. We can see, of course, you know that's going on in various parts of Europe, for example, in Germany. What David and I are arguing is, while normally in the European Union, if you're making an assessment, if a member state or a procuring entity in a member state is making an assessment of exclusion under the norms, under the principles of the European directive, the perspective is well, what impact will this exclusion decision have on the competition in the marketplace? David and I are saying that's important, and that's part of the American process, is to say, okay, if we pull this contractor out, what impact will they have on overall competition? And the data here that's on this slide went to that question in part. What impact would it have if we took out an enormous chunk of the contractors because they engaged in labor violations from a competitive standpoint? But what David and I are really arguing is a different question. And this is where we turn the corner a little bit beyond the directives. Instead of looking at just the impact on the marketplace, we're saying, no, there was a deeper and much more important question. What impact will the exclusion have on the industrial base and on the government's ability to perform its mission? And that's a different question, but we argue that that's actually a primary question in the debarment assessment, because at the end of the day, that's what the procuring system has to do. It has to deliver great goods and services. And if you take, if the exclusion process destroys the government's ability to do that, it's a very serious mistake.
And I could see somebody in a live audience raising their hand and saying, does that mean a company's too big to be debarred? And the answer is no. It means that we have to go through the process. We have to do business with companies that are reputable, and we have to represent to the companies that we want to come and do business with us that there's integrity in our process. But it does mean that you have to think really long and hard about how you do debarments, about whether you debar a whole company, whether you debar a division within a company, whether you debar individuals within a company. When you do this, we're not saying that, for example, Boeing is too big to be debarred. Of course, if they ever see this, they'll probably come and throttle me. But Boeing's not too big to be debarred. But when we looked at, if we had to look at Boeing, we would look at what part of Boeing should we look at, what steps should be taken. And by the way, I know the people in their compliance office at Boeing, they work really hard. Doesn't mean they don't make mistakes, but they work really hard to work within the rules. Since I chose Boeing for the example, hopefully there are no Boeing people in the audience.
Actually, it's actually a great example. So that because when Boeing was suspended by the Air Force some time ago, about 15 years ago, because of a contracting process. Only 3 units within Boeing were suspended by the Air Force. And as David's indicated, a suspension or a debarment by one agency has a government-wide impact. But when that happened, there was a post-mortem that was done by Boeing. What went wrong? What went wrong with our system that we ended up having to be suspended? And the answer it's a really interesting case study, because it shows the nexus between debarment exclusion and self-cleaning, between debarment exclusion and what we call corporate compliance. Because what the post-mortem that was done by Paul Weiss, the Paul Weiss law firm, for Boeing showed was that the compliance system in Boeing, as David suggests, is exemplary. It covers tens of thousands of employees around the world, except that the top executives didn't take it seriously. The few hundred top executives at Boeing didn't take it seriously. They consider themselves in a way exempt from the requirements of the compliance system, and they engaged in allegedly corrupt conduct because they didn't follow the compliance system. So it's a really good example. And in fact, when Boeing was suspended, the first thing that Boeing did, that they stood down the entire company. Tens of thousands of employees stood down for reinforced compliance training. So the Boeing case study that David raised is a very good demonstration of the nexus in the American system and elsewhere between exclusion and self-cleaning, exclusion and corporate compliance. Okay, with regards to the debarment report, we found that as we've discussed, that the existing debarment provisions don't result in debarment of many violators. That we found that the data, even though one could download the data from the Department of Labor website, it really wasn't useful for suspension or debarment officials or for contracting officers, because they could download the data, but then how do you read these tens of thousands of labor violations? Well, what does this mean? How do we understand what labor violations mean in terms of performance risk for the government? That there was relatively little, as David said, labor law expertise outside the Department of Labor available to suspending debarring officials or contracting officers. And so there were four, excuse me, we thought that there were four possible ways for company to address these companies that have engaged in labor violations. The Department of Labor could consider them a debarment. The suspending debarring officials in the contracting agencies could consider the companies for debarment. Contracting officers in the context of they're what we would call in Europe a procuring entity. Whether the contracting officers who are charged with making these qualification decisions, once apprised of a possible violation, they can consider whether or not the contractor was responsible or qualified. And then the last option, which David's touched on before, is requiring the agency, requiring the companies to certify or represent their labor law violations in the System for Award Management. The System for Award Management, SAM.gov, is a generally transparent system of contractor certifications available on the World Wide Web.
So we're getting close to the end here, and so we'll talk about the possible next steps. One of the things our report pointed out is there's lots of data and it's totally inaccessible. Department of Labor has data, Department of Defense has data, contracting offices have data, but it's really not accessible so that anybody can quickly look to see what's going on anywhere. So we made recommendations that they improve the procurement officials' access to and understanding of the information of labor law. And that would include not just the contracting officer, but also the SDOs. Even within the Department of Labor, when we interviewed them and we spent several hours talking to them, even within the Department of Labor, there's divisions, and within those divisions, there's data, and it's not always shared across the whole department. And so that can be vastly improved, particularly in today's environment where the sharing data isn't the problem. The problem is protecting the data from being shared that you don't want shared. We also think that the requirement to have the contractors to disclose their violations in SAM is not unreasonable. If you asked me normally, I would say stop making contractors tell the government about things the government already knows. But in this case, it's the only real practical way that a contracting officer, if you expect him or her to make that decision, would have knowledge about recent labor law violations that have been finalized. And 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 that's pretty much it in that regard. Okay, so the national, what you see here is the explanatory statement that comes with the National Defense, it comes with the National Defense Authorization Act for FY22. The bills from Congress can have a joint explanatory statement when there is not a when there hasn't been a complete conference, or it can have a conference report. There wasn't a complete conference in FY22, so there's a joint explanatory statement. The purpose of the joint explanatory statement is to identify for the public why something that might have been in one version of the bill in the House or the Senate that doesn't wind up in the final version of the bill. And then on occasion, Congress also then puts in other language, which depending on whether you like the language as a government lawyer, you argue it's either guidance you have to follow, or it's dicta, which is no meaning at all. Congress doesn't like it when we say it's dicta and has no meaning at all. And so here's the language on the provision that wasn't adopted about creating statutory debarment. And it requires, as you can see, that the AIRC, the organization that chartered our study, to post the information of our report and to set up some programs to talk about our report and talk about how we can improve labor law compliance. Chris and I will be doing that in the next several months across the DoD. We haven't got dates and times yet.
So what you've heard here is a case study really in dealing with qualification issues. How, when we're assessing contractor qualification, what we call responsibility in the U.S. system, how do we take a specific type of risk, which is the labor law violations? How do we take that into account? This is part of a broader reassessment of qualification in our system. As you know, in any procurement system, in any public procurement system, there are three basic parts of the award decision. There's the qualification of the contractor. Who is the contractor? Is the contractor what we would call responsible in the United States? The technical evaluation and the price evaluation. The technical and the price evaluation are scored. The responsibility of qualification decision in both the US and the European Union member states is typically done on a yes/no basis. Is this contractor qualified or not? Yes or no. It's a binary decision made by the contracting official. In the US, past performance for internal reasons in the European Union, past performance has been more controversial. Beginning in the 1990s, the United States actually pulled under FAR Part 42, pulled past performance out as a separate evaluation criterion, and it's a scored evaluation criterion. If you compare the past performance elements under the FAR, the Federal Acquisition Regulation, with the responsibility or qualification elements under FAR Part 9, they're actually very similar. And that's because arguably, really, qualification or assessment should encompass past performance. It's the contractors, when we're assessing the contractor, qua contractor, logically part of what that contractor is what's the contractor done in the past. But the American system the federal system has pulled it out into a separate scored evaluation factor. It's possible as more data is available and as, for example, more training is available, as bid challenges bring more information into the contracting official, as more market information is available through artificial intelligence, through the internet, as more and more data is pumped into the contracting official, the procuring entity, on the qualification decision. It's possible that in coming years, qualification will no longer be a no-yes question. It will no longer be a binary question, but instead it could be assessed on a score basis. The United States already does that specifically with regards to contractor past performance. That's one element. This is a three-dimensional chess game, because another element is how much of all this should be transparent. If the contracting official is making decisions regarding contractor qualification based on data that's coming from the outside, for example, from other governments, should that entire process be transparent? Or flip it around, if the contracting agency has information that it's using for qualification and other governments, for example, from allied nations, don't have access to that information, are we doing a disservice to our trading partners, to our allies, in not making that information public? Or should the information be made public to stakeholders, taxpayers, to others within the government? So there are many different aspects of this issue of reassessing qualification. From my personal perspective as a professor, this is one of the hottest areas of procurement law, because the changes in technology, the changes in a globalized economy are happening so rapidly, they could transform the qualification decision in the next few years. David?
Well, Chris and I rarely disagree, but the issue of the use of past performance and the sharing of that information is an area where I'm not as ready to talk about sharing our information with others for lots of different reasons, but primarily because the information we have is for our own internal purposes. It is not, unfortunately, well vetted. For example, in the collection of our past performance information right now, one of my complaints is you get a past performance determination from the contracting officer. You have less than 30 days to respond to it. And if you whether you respond or not, whatever was originally submitted to you gets put into that information and is available. And then there is a way to correct it, but it takes forever, and it is not reviewed by some neutral party when you're having a dispute. So while I think it's good enough for our procurement, I don't know that it's good enough to share with others for their procurement. When you go to the debarment and suspension lists, I do know that here in the United States, the federal list is used by virtually everybody because our debarment and suspension lists have due process, and there is potential for judicial review. But we don't seek out the list from the World Bank or the list from the Inter-American Bank, which is between GSA and the World Bank where I worked. We don't seek out any other country's list. We just use our list. So I'm not sure how it's valuable to us, and it seems to be valuable to the people who use our list because it is publicly available. I don't know how we go about addressing the various lists maintained by others. I have an example. When I was at GSA, GSA not only bought things, we also managed buildings. And we were building a building in New York City, and the I'm sorry, it wasn't Queens, it was Brooklyn. The Brooklyn School Board debarred a company we were proposing to do business with. And we took someone brought it to our attention and said that should be a disqualifying piece of information since they were debarred by Brooklyn. And we looked at it and said, yeah, but that's Brooklyn. I don't know that we have a lot of confidence in how they got on the list there. It's no secret that the building trades in the New York City area for decades were infiltrated by organized crime. I have to make sure I use the politically correct terms here. I guess mafia would be inappropriate, but I said it anyway. So as we rethink the qualification issue, and as you look at the various ramifications of it, whether it's a debarment and suspension because you violated a labor law, whether it's because you've gotten good or poor performance on a particular contract, I'm not sure that on the world stage, we've come to a sufficient agreement on what's sufficient due process and what we're willing to pay for that due process. Because at the end of the day, when I was at DOD and GSA, my job was getting goods and services to the end item users in the government. That was my job. And if I spent too much time on things which didn't add significant value, I didn't get my job done. So I'm sure that'll leave you something to chat about after we've finished.
Thank you very much, David. We actually received a text from Professor Sundstrand during the course of this recording. She's very, very happy to hear that our recording is coming together. I think we're exactly precisely on time. So thanks very much, Dave. And again, to our audience, we're very sorry we couldn't be there with you in Stockholm. We hope we have a chance to chat with you virtually.
Yeah. My wife and daughter are very sorry too. They were planning to go. And one last point, I didn't point out to everybody, my background is the Procurement Round Table. Take a look at us online. It's a bunch of U.S. former officials who are busy looking at the system, and Chris is one of our members.
Thank you again. Have a good day. Bye-bye.